All right, welcome everybody, both to our friends in the room and to our friends online. I think I know most of you in the room, but for those of you online, I'm Glenn Cohen. I'm the James A. Attwood, a little bit reverb. I'm the James A. Attwood and Leslie Williams Professor of Law and the Faculty Director of the Petrie-Flom Center, as well as being the Deputy Dean here at Harvard Law School. It's great to see so many old friends and make some new friends as well along the way. As most of you already know, especially those of you in the room, but including those in cyberspace, the Petrie-Flom Center is a research program at Harvard Law School dedicated to legal analysis and interdisciplinary scholarship on critical questions facing stakeholders in the fields of health law, bioethics, and biotechnology. If you don't know about our center, but you're interested in learning more, you'll find more about the center at Petrie-Flom, one word, .law.harvard.edu. That's our website. And while you're there, I'd also invite you to check out Bill of Health, which is our blog. We get nearly 1 million views a year. And we have about 12,000 people who've also subscribed to our newsletter, and you can as well. It's a great way to keep abreast of what's going on. This year's conference is organized in collaboration with two people I'm about to say hello to you for a minute. One is Judith Daar, the Ambassador Patricia L. Herbold, Dean and Professor of Law at Northern Kentucky University Chase College of Law, and O. Carter Snead, the Charles E. Rice Professor of Law and Concurrent Professor of Political Science at the University of Notre Dame. And if you two want to say a quick hello, I'd love that.
Thank you, Glenn. So sorry.
No, please.
Always the dean, just jumping
you're the
in.
dean. You gotta get in there. There you go.
Thank you.
Absolutely.
Good morning, everyone. Thank you so much. It's such a pleasure to be here. And this program has been long in the planning, thanks to Glenn and Susannah. And I want to give a shout out to Laura as well. When Susannah and Glenn contacted me well over a year ago and shared this idea, I was very enthusiastic. And they said that their goal was to present a conference on this topic with a wide range of points of view. And we talked about what that meant and how we would bring together this type of a group at this event with the subject matter at hand. And I have to say I'm incredibly proud of the program that we've put together, and it's because of this person to my right who is marvelous and the wonderful staff at the Petrie-Flom. And today I think you're going to be treated to a marvelous range of points of view. We also, and this is thanks to the audience, we're able to amass an incredibly comprehensive program substantively. You'll learn about legal principles, jurisprudence, epidemiology, cutting-edge technologies, Aristotelian ontology, which I read about for the first time since college, and was a true pleasure. So I'm so thankful to be part of this. I welcome you on my behalf and, of course, on behalf of Petrie-Flom, and look forward to today's events.
Yeah, I would just echo what the Dean said. This is a great treat for me to be part of this process, even the planning and working together with these wonderful folks, Susannah and Glenn and Judy and their extraordinary staff, Laura and Aaron, and it's just been a real treat. And I think I'm very grateful again for Glenn's vision for this event. It's deeply interdisciplinary. It is not siloed in terms of disciplines. It's not, and more importantly and more deeply, it's not siloed in terms of perspectives, as often happens in these kinds of gatherings. You end up just talking to your friends. And it seems to me that the only way forward on difficult, complex questions is to meet and engage with in a charitable and friendly spirit others. And again, I think, and not to be corny, but I think actually that friendship is ultimately the only pathway forward on polemical, polarized, and neuralgic questions. And so I look forward to getting to know all of you and to begin friendships and renew old friendships, and just want to express my gratitude again to these wonderful people up here and to all of you for joining us.
Well, I couldn't be more grateful to work with these three people on the volume, but also to work with all of you in the room on this amazing project. I also wanted to express some gratitude to a couple other people. One is the Oswald D.N. Kamen Fund at Harvard University, and the second is the ASRM Center for Policy and Leadership. And then I thought I'd just say a very few words for framing the conference today. We're focused on the rapidly changing landscape for embryo law and ethics. Since the 1980s, of course, it's been possible to create human embryos outside of the body and preserve them through cryopreservation. That innovation, though, has brought with it a lot of legal and ethical debates, even as the science and technology have continued to evolve. Actually, at our program last night, we talked about some of the next frontiers, and some of the conference papers today will also be about those frontiers. Today, in this edited volume that will result from this conference as well, We'll discuss everything from the evolving questions surrounding IVF to genetic testing to gene editing of embryos to gametes derived from stem cells to the implication of human embryo research in space. Right, I hope you're listening there, SpaceX investors, right? And courts have struggled with legal questions, including relating to the disposition of these embryos and related legislative actions. Questions pertaining to embryos include issues concerning legal personhood, liability for embryo destruction, regulation of the IVF industry, donor and offspring interests, parental rights and responsibilities. As Carter said, we have scholars from many different perspectives and many different training in the room. That's not accidental. In a moment where we're having very deep societal debates, we hope to disagree agreeably. The goal is to explore collectively the challenges and opportunities for legal, regulatory, and ethical topics at hand. Now, for the writers in the room, we've done this about 13 or more times. We've turned these annual conferences into an edited volume with a major academic press. Today's conference will give you some live feedback on your first draft, but after today, you'll also be getting more direct feedback from an editor assigned to you, and the goal is to get your revised draft by September 1st. The editors will consult with you. We're happy to talk more, but the most important thing to know is, because we really mean it, is we do want your chapters to be 5,000 words inclusive, I'm going to underline that word, inclusive of footnotes, right? So that means they're short, they're punchy, they're going to be awesome, but they're going to be no more than 5,000 words. We also use a modified Blue Book citation style. We'll send you a sample, but the good news is it's Blue Book Light. We've tried to make it easier, and the press has been willing to do so. All that information is going to be sent to you in a follow-up email. Before I do some thank yous to the team, I also want to give one more piece of information that's very important. That's where the bathrooms are located. If you take a right here and take another right, you'll basically end up at the washroom. Those of you watching at home, hopefully you know where your bathroom is, but for the people in the room, that's where it is. Okay, so then let me just say a few thanks before I turn it over to Susannah Baruch. There's a huge number of people who worked very hard to make this possible. I just want to give them a shout out. One is Laura Chong, who's already been mentioned once, our financial administrative director. Another is Lisa Gorelick. Oh yeah, we can do individual applause. Lisa Gorelick, who's our program coordinator and digital specialist. Third is Erin Scott, our communications manager. And then Sophia Palmieri, who's our postdoctoral fellow. And with that, I'll turn it over to one more person who deserves applause. That's the executive director of the Petrie-Flom Center, Susannah Baruch.
Thanks, everyone. I always feel like our annual conference is like Thanksgiving or Christmas, like all the people you've been waiting to see the whole year are finally in the room together, and then we can argue about things, and it'll be great. It is a privilege to share this project with not only Glenn, who I get to work with every day, but with Judy and Carter, who are two really key scholars in this area, whose work I have followed for several decades, and that's really been a delight. We are delighted to be welcoming folks watching on the live stream. Due to our limited time together, we are only going to be taking questions from folks in the room to sort of keep with the workshop vibe of the day. There will be caffeine and snacks throughout the day in the room. Again, at home, you do you. I want to just make a couple notes looking at the day. The first 15-minute break is at 11:15. We are having a photographer come, and we're going to do photos of each panel as well as a group photo for the whole, for everybody in the room. The lunch break will be at 12:30. It'll be in the next room over. The Wi-Fi information is in your folders. Glenn mentioned the bathrooms. Those are probably all the minutiae you need to know. But I do get to tell you about one of Petrie-Flom's favorite and best friends, which is the timer gizmo. Some of you saw this in action yesterday. One scholar calls our method the autocratic administration of time in the interest of democratic distribution of time. So for today's purposes, each presenter gets 10 minutes. You will see that the green light is green. When you begin, it will turn yellow to let you know you have 2 minutes to wrap up, and it will turn red when your time is up. And when the light turns red, people in the room feel free to rustle papers and otherwise look unhappy to crowdsource the enforcement of the time limit. After each panelist on the panel has spoken, so once all the panelists have gone, the moderator of each panel will call on people in the room for questions and ask perhaps the panelists if they have questions for each other. When presenting, please do speak into the mics so that we are recording and live streaming. Questions should be short and end in a question mark. If you are asking a question, please wait for the mic to be brought to you. That way the audience can hear you as well. And we will post a recording of the day at the end. It is my pleasure now to ask the members of the first panel up to join me on the stage for panel 1, IVF Past, Present, and Future. Thanks. And if the panelists would bring their name cards, just if you have them handy, that would be great. Sure. So just for the panelists, I think we're going to go in order as on the agenda. So Dove and Jinping, Laura and Timo, Yaniv, and Katie. Starting at whichever end makes the most sense. We'll start with Dove here. Up to you. Yes. I am not going to do an introduction of our panelists. Their names are on the agenda. If you're at home, they're on the agenda posted online. But suffice it to say, we start with IVF and a number of perspectives on where we are and where we might be going in the legal and ethical questions that surround IVF. And we'll start with Dove Fox.
Well, hi. Pleasure to kick things off today, thanks to our extraordinary organizers. Susannah here, thank you. Glenn, Carter, and Judy. To Laura Chung for making everything go so smoothly, and to all the staff who are making this conference possible. It's a special pleasure and privilege to join friends old and new for today's intellectual feast. Mary Ziegler and I wrote this short paper together in hopes that it might situate today's discussions by making a relatively modest claim that the regulatory vacuum around IVF in the United States today is no accident. Instead, it's the remnant of a specific political failure from 1979. Let me share a bit about how that came to be, why it matters, and what we propose to do about it. Now, you're no doubt aware that in February 2024, the Alabama Supreme Court held in the LePage decision that frozen embryos have the moral and even legal status of children, at least to the extent that dropping a tray of embryos is no different in that court's view, legally speaking, than running over a child with your car. In the wake of that decision, 3 of the state's major IVF clinics halted treatment. The legislature, in turn, scrambled to pass liability protections. Clinics did eventually reopen, but the court's logic that frozen embryos are entitled to protection as persons remains good law. Alabama is both exceptional and symptomatic. Exceptional because no other state has gone quite so far to date. Symptomatic because the legal vacuum that made the LePage ruling possible applies nationwide. There exists, not in Alabama nor anywhere in the U.S., any federal statutory framework to govern IVF or any uniform standards about embryo creation, embryo storage, embryo disposition, or the genetic screening of embryos. So what we have here is a medicine of miracles that for almost half a century is responsible for the birth of more than 1 million Americans, that operates in a long-standing state of legal uncertainty and confusion. Let's see where that started. The legal vacuum traces to a political failure in 1979. We argue this case by recovering 2 episodes from IVF's first decade that the legal scholarship has largely forgotten. One is the world's first IVF lawsuit. The second is the Carter administration's Ethics Advisory Board, EAB, which conducted national hearings later that year and the next to produce a workable framework. And despite the great promise that we see in that framework, it was never implemented. We start in 1973, the same year as Roe v. Wade. Doris Delzio sought treatment for fallopian tube scarring that surgery was unable to correct. She and her husband wanted a baby. Doris's physician at Columbian Presbyterian was a Dr. Shettles. He was a maverick researcher who succeeded in creating an embryo in a test tube using the couple's egg and sperm. But before he could transfer the resulting embryo into Doris, Shettles' senior colleague, a Dr. Vanderveer, poured the contents of that tube down the drain, citing his own ethical concerns. The Delzios sued Vanderveer and the hospital for intentional infliction of emotional distress with a separate damages claim for what's called conversion, basically theft. What's interesting here is that the doctrinal terrain that the case came upon was basically empty. No statutes applied, at least not in any straightforward way. And it seemed like a reach to argue that constitutional cases like Skinner and Eisenstadt about sterilization and birth control extended to IVF. So the parties in Delzio were reasoning from first principles. The Delzio trial scrambled the categories of the emerging abortion debate. Consider the plaintiffs, the Delzios, were devout Catholics. They called their embryo their baby, framing the case as a murder trial. And yet also, and confusingly, they pleaded conversion as well, namely treating that lost embryo as a form of legal property. The defense did the same thing in reverse. In the pro-life register, they invoked embryos as persons to be, who they say never could have been. But then in the pro-choice register, they argued that what had been lost when Vanderveer flushed the embryos down the drain was just a clump of cells. The defense attorney argued that he had prevented the birth of no human being, but a monstrosity. And then both sides also claimed the mantle of patient autonomy, whether expressed or implicit. The verdict was characteristically ambiguous. No conversion, the jury said, declining to treat the embryos as property under the law. But they did find liability for emotional distress, albeit very limited, just $50,000 of the $1.5 million that the plaintiffs had asked for. Here's another fact about the Delzio trial, largely about this experimentation claim that it was unethical to create babies that could be born with 2 heads or 3 hearts. Midway through the trial, Louise Brown was born in England, the very first IVF baby. Bouncing, beautiful Louise Brown, that first baby that Doris Delzio wanted to have. And she never would, and would never become that first IVF mom she had hoped. The lesson of this trial is that the binary logic of the abortion debate, pro-choice, pro-life, it doesn't define IVF ethics or law, not then and not now. The Del Zio trial, combined with the birth of Louise Brown, pushed the Carter administration finally to act on a 1975 congressional mandate requiring ethics review before federal IVF research funding could proceed. Health Secretary Califano chartered the Ethics Advisory Board in 1978. Its 11-member panel of ethicists, scientists, lawyers, and religious leaders represented genuinely diverse viewpoints across the board, resembling in large part the team that our organizers have brought together around this table today. The EAB board held public hearings in 7 cities nationwide, from Bethesda to Seattle, calling over 100 public witnesses. These were physicians, infertility patients, theologians, disability rights activists, feminist scholars, and ordinary citizens. The point, the goal of these hearings was to surface a wide, ideally comprehensive range of American opinion on matters related to IVF, specifically funding and practice. But the IVF hearings under the EAB did more than that. Across predictable disagreements that remained, the witnesses, I think, surprisingly converged on 4 principles of common ground. Notwithstanding their disagreements, they agreed in a near consensus on these 4 principles. 1, respect for embryos. Witnesses across the spectrum agreed that embryos warrant some degree of protection. Father Richard McCormick, one of the EAB members, his testimony exemplifies the texture of these testimonies. Father McCormick was a Catholic opponent of abortion. He distinguished, however, genetic individuality, which is present at conception, from developmental individuality, which emerges later in the life of prenatal development. Embryos warrant respect, he concluded, but not the full status of born persons. His was not a pro-life or a pro-choice position as mapped onto IVF. It allowed embryo research to continue using federal funds, and it also attracted feminist scholars who shared his anxieties about the commodification of reproduction. Respect for embryos held appeal across the board. That was the first area of convergence. Second, anti-commercialization. A wide range of folks who testified were deeply worried about the development of a market for reproductive technology that would be driven by profit over patient welfare. Patients, that is fertility patients, seeking treatment, wanting a baby, and also the welfare of resulting children. Among those who expressed clear agreement on this principle included disability advocates, feminists, religious conservatives, all of them worried about commercialization. Third, opposition to eugenics. Obviously, a weasel word, and we'll, I'm sure, get into that later today. But to be clear from the outset, pro-life physicians invoke the history of forced sterilization under the Nazi regime and our own state regimes of forced sterilization here in the US even before the Holocaust. Pro-choice feminists, in turn, worried that genetic screening would devalue children with disabilities and other disfavored or unpopular traits. This concern, too, was cross-ideological. It anticipated the contemporary debate about polygenic screening that we'll wade into this afternoon. Finally, child welfare. The interests of the resulting children were paramount across testimony from folks from all walks of life, all religious backgrounds, and all ideological priors. In May of 1979, the EAB finally issued its report. The board concluded that IVF research was ethically acceptable under specified conditions: strict informed consent for patients, limits on embryo creation, a 14-day cap on embryo development, and an ongoing review process. The report didn't paper over disagreements about the moral status of embryos. It acknowledged them explicitly, but it identified a practical framework that could command support from across the range of views that were represented. This was a carefully calibrated compromise, but it was never implemented. Health Secretary Califano declined to implement it, fearing anti-abortion backlash from a coordinated letter campaign. Reagan won election in 1980 and let the board's charter expire. The de facto federal funding ban remained in place for years. The deliberative model of EAB's work showed overwhelming promise that should have succeeded. Its ultimate failure was due to political timidity, and the legal vacuum that IVF now inhabits is the direct product of that political failure. I'm going to very quickly point to some future directions we can cover in the Q&A. Today, almost 50 years later, 4 shifts make the EAB's vision more necessary and more possible. First, polygenic embryo screening with multi-billion-dollar firms offering risk scoring for traits like autism, IQ, and height. This eugenics concern is no longer hypothetical. 2, access. Costs are skyrocketing to use IVF, and insurance coverage is patchy and limited. 3, the post-obs jurisprudence, like LePage, opens personhood doors long thought closed. 4th, coalitions have realigned. For example, the Southern Baptist Convention has now joined Catholic clergy in opposing IVF. The Alabama backlash, however, and high public support for IVF, I think, gives hope, cause for optimism about prospects for rich deliberation that meaningful legislation would require. Our proposal is a reconstituted EAB, same deliberative model, new questions, that would include the voices of folks entirely absent in 1978, sexual minority patients, single parents by choice, lower income patients, people conceived through IVF, and a wide range of faith traditions. The key questions for today would, too, be focused on the live controversies before us. Thank you so much, and look forward to future conversations.
Thank you. Our next speaker is Jinping Hu.
Hi, everyone. I'm Xinping. I'm a first-year PhD at UC Berkeley, and it's a joint work with my co-author, Professor Alice Magaria at University of Zurich. And our title asks a question, is it possible to protect embryo without getting in the way of IVF? And over the next few minutes, I will suggest it's harder than it sounds. So as Dov has covered LePage, I will start our story from what happened post-LePage. As Dov mentioned, the clinic paused their services after LePage came, and in 19 days, the legislators actually passed a bill to provide wide civil and criminal immunity to the providers. As you imagine, the immediate crisis was resolved. However, our claim is very similar to what Dov and Mary made in their paper, is that that reassurance doesn't answer the right question. Immunity does let clinics keep operating, but it doesn't settle anything. The law still treats the embryo as child. It just promises not to enforce that against IVF providers for now. So this is how we understand the current situation. As you imagine, after LePage, people started finding that IVF is actually genuinely popular. The support comes from cross-party, and many of these lawmakers, themselves or their voters, actually use this technology to build up their family. So banning it is off the table. But here's the catch. What is protected is the word IVF, the label, but not practice underneath. It doesn't tell us how many embryos a clinic can create, how long they can be frozen, and what happened to the ones never used. In that sense, the law is unsettled. And here comes the third side of the bind, the squeeze. These lawmakers, they cannot ban IVF without angering the public. In the meantime, they cannot fully embrace it without breaking with the pro-lifers space they depend on. So caught between the two, there is really only one move available in addition to just doing nothing. That is, leave the label IVF legal, while in the meantime, quietly regulating the practices underneath. For example, caps on embryos created, limits on freezing, restrictions on screening, and rules on the surplus. That is what we call embryo protective regulation. And this is the topic of the whole talk. To find out if there is any lawmakers really proposing this kind of bills, we create our own original data set. We read each bill's actual text from Dobbs to the present, with February 2024, that is LePage, flagged to isolate LePage's response. So far, we have covered 24 states with 85 directly IVF-relevant bills, and there are 40 have already been enacted. So here are our three findings. First one is actually state immediate response aligns with the dilemma we just identified. It's a delicate balance between the IVF and the embryo. Start with Alabama. It's an emergency patch post-LePage. In this single week after LePage, lawmakers introduced a menu of competing fixes, from Democrats' bill declaring a frozen embryo is not a child, to several Republican bills giving immunity to the providers. And the legislatures ultimately passed exactly the middle path one, SB 159, which provide broad civil and criminal community for anything done during IVF, and rejected the rest. That include the Democrats' bill and another Republican bill, which anchor the immunity on standard of care. And it also rejected an amendment that would have kept providers liable for intentionally discarding an embryo. The sponsor said he had drafted it with personhood language in the beginning and stripped it out to get it through. He called the situation a legislative band-aid. And we saw another very surprising contrast is state Louisiana. That is the only state, probably you know that, whose statutes already grant embryos legal status and bar their intentional destruction, while still allowing IVF to operate within state. After LePage, it passed Act 116 in year 2025, even though LePage doesn't happen in Louisiana. So this bill shielded nearly every step of the IVF process from prosecution, such as screening, transportation, etc., but keeping the disposal ban and voiding any agreement clause directing an embryo's destruction. So even Louisiana, as embryo protective as a state gets, runs the same middle path, keep the IVF label stand while outlaw the specific practices. And Louisiana and Alabama are not the only two states that rushing to protect IVF post-LePage. We found more bills in our legislative mapping, and we want to make it clear that their protection level is not the same. We find the protection level as thin as Georgia, which only say, we protect IVF. But in states like Delaware and Colorado, they protect, basically everything in IVF because they define fertility treatment broader than IVF. So here we want you to take away is, when state say we protect IVF, that doesn't mean anything. And here comes our whole data set. On the left is the carve-out. That is, the exceptions the lawmakers add to the personhood bill, saying that this personhood bill doesn't apply to IVF. We think there are two reasons to dot it as a safe guarantee. Because first, most bills do not have a carve-out. Of the 33 defining personhood to reach the frozen embryo, we found 27, that is the majority of them, contains no carve-out. In addition to that, more strikingly, we see proposals in Idaho, Arkansas, and Colorado moving to repeal the carve-out they had in their books. So the momentum behind each proposal differs, but it's safe to say that carve-out is not safeguarded, it is assumed to be. On the right, we want to show the rapporteur of embryo protective legislations. Outside Louisiana, so far, no state has yet enacted a restriction on embryo handling, but the proposals recur across every instrument. For example, Louisiana building embryo caps into the consent forms, and Kansas tries to criminalize embryo destruction through 3 recurring legislative sessions. We also saw other bills try to regulate clinics in many other states. So the toolkit is assembled and sitting on the shelf. So, if a state pulled their tools from the shelf, what would happen to IVF? For that question, we have Italy. Italy is not randomly selected. In Chief Justice Parker's concurring opinion in LePage, he actually pointed to those European countries that, in his word, allow IVF to continue while drastically reducing the chances of embryos being killed. So he wanted to create this kind of balance. And Italy was one of the examples he cited. The law was Italy Law 40, which is passed from 2004. The rules include no more than 3 embryos can be created for a single simultaneous transfer. No freezing, no PGD, and limits on who can access it. For example, it excludes same-sex couples to access IVF. If you cannot freeze the embryo and you cannot discard one, then every embryo created has to be transferred together in one shot. So you can imagine this law will impact how IVF is practiced on the ground. Here is some data we found in literature. The left panel is what the law did. We found a study of more than 10,000 cycles before versus after 2004, found that the delivery rate per attempt fell from about 20% to 16%, and it held after controlling age, hormones, and eggs retrieved. Alongside that, multiple pregnancy risk rose and cross-border care quadrupled. So with that, you can imagine the equity of access to IVF definitely decreased because, people with lower income or elderly people, they cannot travel to another country to access IVF. In year 2009, the Constitutional Court struck the law down for ruling out individualized medical judgment. The right panel is what moving the law did. Even though it used a different data set, it shows that the pregnancy rate per started cycle raised from about 20 up to 23.5, with fewer cycles needed per patient. So as you can see from this, the direction of removing this bill is very clear. So with that, we want to show our 4 propositions, and we want you to take away today. First, legality is not availability. If you say IVF is protected, that doesn't mean anything. And second, you have to judge the mechanism of each embryo protective bill, not the label. A cap on embryo transferred can be good in some way, but a cap on embryo created is another thing. Third, if Italy and Germany is cited as proof, the full record has to be shown to voters and experts. Fourth, gaps in evidence weigh against the regulations, and the proponents should carry the burden. They should name the practice, they should name the harm, and why a lighter alternative won't do the same thing. And last but not least, lifting limits is necessary but not sufficient. Even after Italy's court removed this restriction, the inequality the law created doesn't vanish. So we want to make sure that in addition to lift all the restrictions, we have to invest in our infrastructure of IVF. So with that, thank you all.
Thank you, Jinping. And next we have Laura Voltaire and Timo Minson. Are you co-presenting, you still only get 10 minutes. That's the rule.
Oh, I thought we had 20, but
Sneaky.
I will stay here, so Laura has the
Wonderful.
stage. I will just add.
Good morning, everyone. Let us offer for you some comparative. Okay. Good morning, everyone. Let us offer you some comparative perspective in regard to prenatal genetic testing. I'm Laura Valtere, presenting together with Professor Timo Mintzen. This research is motivated by our long-standing interest in personalized medicine, a subject matter that was the focus of my dissertation, and also of Timo's former research in this field. I originally viewed reproductive medicine from a pro-innovation standpoint. Therefore, we intended to contribute to this conference by presenting our research on polygenic risk scores in Europe and in the US, which we discussed with Glenn last summer. However, what we realized was that we are not yet there at that stage in Europe, as technology such as prenatal genetic testing still raises questions that must be addressed first. And secondly, according to the majority view in Europe, polygenic risk scores, as technology is not yet advanced enough. PGD is much more widely available in the US, so we initially were to identify areas where Europe could learn from the US. However, our research indicates that the US approach has some negative effects on the fundamentals on which the current liberal PGD system is based. Congenital anomalies affect approximately 2.5% of births per year. These conditions are a leading cause of fetal and infant mortality and morbidity in Europe and in the US. Genetically inheritable anomalies are passed on by carriers. In Europe, these account for 3 to 6% of the population, whereas in the US, this figure is 6 to 8%. The results of PGDs enable the selection of embryos without genetic abnormalities prior to implantation as a part of IVF procedure. Other molecular tests can be performed during pregnancy. If these tests indicate abnormalities, it's possible to interrupt a pregnancy that has already progressed, yet it is physically and psychologically burdensome for the affected. The legal framework of PGDs in Europe, there is no legal framework for PGDs at EU level. It is a matter of national competence. Until the mid-2000s, PGDs were generally banned in many European countries and only available under strict conditions under others. Following the 2012 European Human Rights Court judgment, which ruled that access to the tests was a right to private and family life, this changed. However, still, in most European states, PGDs is only available as an exception. In Germany, for example, as well in France and the UK, tests are only available if the parents carry a genetic predisposition or if there is a high likelihood that the embryo will be affected by a defect leading to miscarriage or stillbirth. There are 3 other requirements. The most critical of these is the decision of an interdisciplinary ethics commission, which is a mandatory requisite for the access to PGDs. In turn, there is very little regulation in the US, as we know. The field essentially relies on non-binding professional guidelines and industry self-regulation. The constitutional right to privacy has been invoked in abortion cases. Drawing on this framework, decisions relating to pre-implantation genetic testing should also be protected from excessive regulation. One factor that has created a regulatory vacuum is argued to be general absence of state-funded healthcare. Another is that introducing regulation could risk reopening the highly sensitive abortion debate. I give a word to Timo.
Right, the ethical debates, right.
Timo, will you speak into the mic?
Yes, the ethical debates around PGD are, of course, long-standing and well-known to this expert audience, so I will therefore not elaborate on it in full, but only highlight the tensions that matters, I think, for the comparison, the legal analysis. So on one side, there are the concerns about the moral status of the embryo, discrimination, eugenic selection, designer babies, yeah, and unequal access. And on the other hand, is the view of PGD as a means of preventing profound suffering for the future child and family, and as a way of supporting responsible reproductive decision-making. However, this is not a debate, I think, that can always be resolved through proportionality, empirical evidence, or science evidence, or utilitarian balancing. Some positions are really grounded in religious or moral beliefs that are bogged down in their own logics, right? And for those positions, the protection of embryonic life may be an intrinsic commitment, not merely one interest to be balanced against others. And this makes the European position especially complex, I would say. In some national systems, the prenatal testing during pregnancy may be more readily available than PGD before implantation. That creates difficult tension. Parents may be restricted from making choices at the embryonic stage, while later facing more burdensome decisions during pregnancy. So the central issue is really how the law should mediate between embryo protection, reproductive autonomy, self-determination, and women's rights. And this, I think, leads then to the questions that I think should guide the next slides. Should the law support the parental decision to have a healthy child? Should it primarily protect the embryo? How far may individual reproductive choices extend, especially when they concern the serious genetic disease rather than enhancement? And everybody who has seen these diseases in action in real life, I think, understand that this is a crucial question. Are there real obstacles in Europe to expanding access to PGDs on the basis of autonomy and self-determination? And does the moral, liberal US model offer lessons for Europe? And in Europe, we also have always this practical concordance that you need to balance the fundamental rights of free choices, but also the human dignity that should remain untouched under Article 1 of the German Constitution, which is one result of the Nazi regime, of course. And then, of course, the question that you also need to ask is, when does the proportionality principle help us to reach utilitarian decisions, and where is it less, or reasonable decisions, and where is it less useful due to impenetrable religious beliefs?
Addressing just one of these questions, should we support the parental decision to have a healthy child or protect the embryo, or make this contingent on collective decisions or industry policy? In many European countries, including Germany, a special commission procedure is required for PGD. A case-by-case assessment is carried out to determine whether the necessary criteria are met to authorize PGD. Secondly, access is further constrained by the limited number of competent ethics commissions. Consequently, some patients have to travel long distances, resulting in de facto restrictions on access based on region and financial resources. Furthermore, the decisions made by these commissions are inconsistent both within and between the commissions. This creates legal uncertainty and contradictions. In addition to an individual's genetic background, ethics committees also consider psychological, social, and ethical factors. This makes the case-by-case assessment particularly complex, as it necessitates the disclosure of highly private psychological aspects outside the confidential doctor-patient relationship. The situation in the US, what we have found out is that the clinics in the US have declined to proceed with embryo transplantation following PGD results, indicating abnormalities based on their internal policies. According to the Ethics Committee of the American Society for Reproductive Medicine, it may be ethically acceptable to decline the transfer of an embryo likely to result in a life-threatening condition, even if the parents request it. This effectively discriminates against prospective parents and restricts the right to make autonomous reproductive decisions, thereby undermining the right to privacy. The study by Takashi and others revealed that couples often felt discriminated against those who had not undergone PGD, as well as deprived of what they perceived as their last chance to become parents. The central tension lies between professionals asserting their co-responsibility for the welfare of children conceived with their help, and the principle of individuals having the right to make their autonomous reproductive choices. However, such decisions are often motivated by the desire to improve success rate statistics, as abnormal embryos often lead to miscarriages. It is evident that the absence of state regulation has resulted in the emergence of industry self-regulation, characterized by the implementation of internal policies that are arguably commercially motivated. These policies have had a detrimental impact on the fundamental right to privacy in the US, significantly restricting reproductive choices. Coming to the conclusions. In conclusion, PGD can be regarded as socially beneficial innovation that empowers prospective parents to bring healthy children into the world. However, as we have explored, it is not without its limitations. In Europe, these limitations are contingent on the availability of PGDs and the ad hoc decisions of interdisciplinary committees. The system is complex to reach due to its low number of such commissions and the infrequency of their meetings. Furthermore, the decisions are not consistent, which can compromise legal certainty. More critically, this framework undermines women's interests and rights in favor of blasphemers' protection, raising profound concerns about reproductive justice, whereby highly personal reproduction decision-making is made dependent on the Commission decisions. Conversely, the United States offers a stark contrast through its lack of state regulation and industry self-regulation. Although this approach seems to protect privacy and reproductive autonomy, it conceals significant vulnerabilities, such as the lack of meaningful oversight, the commodification of reproductive technology, the emergence of reproductive tourism that exploits regulatory variations between countries, and ultimately restriction of the right of privacy. And I give the last
I think we're going to
word.
have to leave it there. We'll come back to you in Q&A, I am sure. Thank you very much. Yaniv, thank you.
Good morning, everyone. My name is Yaniv Herod. I'm a professor at Georgia State University College of Law, and with me here today is my co-author, Lisa Vertinsky from the University of Maryland School of Law. First, we'd like to thank Glenn Cohen, Susannah Baruch, and Laura Chong from the Petrie-Flom Center and Judy Daar and Carter Snead for putting together this important conference and inviting us. At the presentations we've heard so far and the drafts we've seen, we see an underscoring of the fact we are living in a deeply fractured moment in reproductive law. On the one hand, reproductive technologies continue to advance rapidly and are an increasingly essential pathway to family building. On the other hand, we are seeing concurrent judicial retreats where courts are increasingly failing to protect or outright dismantling the rights of individuals and families who rely on these technologies. In our talk, we want to focus on one specific and particularly troubling type of case. We're all familiar with what Dov Fox calls reproductive wrongs. And in the Georgia cases Lisa and I are looking at, the misconduct isn't subtle. These are not closed cases with factual or legal ambiguities. These are cases of textbook commercial fraud, misrepresentation, breach of warranty, and negligence. Yet when parents bring these claims to court, the judges relabel them as barred wrongful birth claims and dismiss the lawsuit. We argue that what we are seeing in these cases isn't an organic evolution of common law, but a total breakdown in common law reasoning. We will dedicate the rest of our comments this morning to looking at what wrongful birth has traditionally been. Then we'll talk about the mechanics of what we call the judicial creep of wrongful birth. We will look at how this phenomenon has unfolded in the Zytex litigations in Georgia. And finally, we'll briefly discuss the implications in a post-Dobbs legal environment. Traditionally, wrongful birth was a narrow, highly contained cause of action. It was a subspecies of medical malpractice where a prenatal provider negligently fails to diagnose or disclose an abnormality in an embryo. And as a result, the parents are deprived of the information they would have needed to decide whether to terminate the pregnancy. It was an informational injury that was limited to a clinical setting. Now, because the claim itself assumes the parents would have considered an abortion, and therefore the non-existence of the child, courts have never been comfortable with this doctrine. But even when courts struggled with how to handle wrongful birth claims, and struggle they did, they still did their jobs. They ground through the elements: duty, breach, causation, damages. It was controversial, but it stayed its lane. What we are seeing today in the Zytex cases in Georgia is completely different. It's not an incremental expansion of the elements of wrongful birth. It's total doctrinal displacement by something that feels like wrongful birth but isn't really. Here's how it works in 3 steps. Step 1 is the trigger. Step 1 is the trigger. The plaintiffs argue, if the company hadn't lied to us, we wouldn't have bought this specific donor tissue. And although the parents never say this out loud, the child would not have been born. Step 2 is the recharacterization of the claim. The court hears this argument and says, aha, you said if I had known the truth, the child wouldn't exist. That means that your fraud or negligence or any other claim is secretly a wrongful birth claim masquerading as something else. And step 3 is the override. The court invokes the maxim that life can never be a legal injury and dismisses the case. In other words, the court takes ordinary but-for causation language and turns it into a trapdoor that triggers a liability shield starting at the moment of conception. Once an embryo is conceived, the law basically says no matter how much the sperm cell lied, they are effectively unsuable, because to say otherwise would be disrespectful to the symbolic value of the life of the child. The best demonstration of this legal maneuver is in the 5 most recent cases against Zytex, which touts itself for being America's longest running sperm bank. Here are the basic facts. Starting in the early 2000s, Zytex marketed several donors as healthy, highly educated, with no criminal record and no personal or familial background of genetic disorders. In reality, one of the donors, later identified as James Aguiles, whom our friend Dov here has created an entire fascinating podcast on, had a documented history of severe mental illnesses, repeated institutionalizations, no academic degrees, and a rich criminal record, including spending 8 months in jail. The 2 other donors, named in the most recent set of cases, have identifiable, visible genetic disorders that ought to have been immediately recognized in a basic physical examination by any competent medical practitioner. So Zytex's representations about the donors were blatantly false, and dozens of families relied on these representations and had children diagnosed with the donors' conditions, with about 24 families bringing lawsuits against Zytex since 2014. Again, these cases are not malpractice suits about a doctor missing something in an ultrasound. And they are not closed cases of factual or legal ambiguity. They are clear cases of fraud. But the Georgia courts collapsed all the plaintiffs' claims for damages in all of these cases into wrongful birth anyway. In 2020, one of the cases, called Norman versus Zytex, reached the Georgia Supreme Court. The court tried to walk a tightrope. It said, well, okay, not all claims are necessarily banned as wrongful birth, only the ones that characterize the life of the child as an injury. But it didn't give the lower courts a map to figure out which of the 13 causes of action were okay and which weren't. Instead, it sent the lower court a strong signal by starting its opinion with the declaration that respect for life is the heart of our entire civilization. On remand, the trial court, being unsure how to distinguish between allowable and non-allowable claims, basically drew an arbitrary line in time. It held that any injury that occurred before conception could proceed, but any claim based on damages that happened after conception was to be dismissed. And once that order came down, the parties negotiated for another year before they settled in June 2024. Now, if the outcome in Norman left a small window open for consumer safety and corporate accountability, the courts closed that window in the next round of cases. In 2021, 14 families filed 4 new lawsuits against Zytex with the same basic facts, same claims, same categories of wrongdoing. And this time, the courts went even further. The court said the plaintiffs, in their complaints, alleged that they would not have purchased this sperm had they known the truth. And the plaintiffs incorporated that allegation by reference into every cause of action. Therefore, all the claims are, quote, classic wrongful birth claims. And that short characterization was enough for the court to summarily dismiss all 13 causes of action in all 4 cases. The cases were appealed, consolidated, and just a few months ago, in February 2026, the Georgia Court of Appeals affirmed the dismissal on the same grounds. As of yesterday morning, the case is still pending on a cert petition before the Georgia Supreme Court. Excuse me, and if cert is granted, then you can expect an email from Lisa and me asking you to join our amicus brief. Now, all this has obvious implications for the art industry and consumers of reproductive products and services. If liability disappears whenever a child is conceived, then misconduct for reproductive products and services, misconduct for reproductive products and service providers become low risk, and procuring or buying these products and services becomes high risk. In that respect, the Zytex rulings are a corporate defense attorney's dream. They provide a plug-and-play blueprint for dodging liability for any actor in the reproductive industry and possibly even outside the industry if the wrongdoing somehow involves the conception and birth of a child. For the children and their families, this outcome creates a particularly cruel irony. The very families and children struggling with real impairments are foreclosed from recovering the funds they need to treat these impairments in the name of symbolic respect for the child's life. But the most concerning part is what we are seeing in Georgia is likely a preview of what is likely also to happen in other states. 17 other states currently ban or heavily restrict wrongful birth, and 8 more states have no law on wrongful birth. In our current post-Dobbs legal environment, we anticipate that what we are seeing in the Zytex cases might become the blueprint for similar moves by other state courts, undermining consumer protection in similar and perhaps other types of cases. Thank you, and we look forward to your comments.
Thank you, Yaniv. Catherine Krashel will be next.
Okay. Hi, everyone. I would like to echo others' comments thanking the organizers today. In a previous job, I had a lot to do with events like today, so I have a deep appreciation for how smoothly everything is running. Thank you. Okay, so for patients undergoing IVF, for anybody in the room that's involved with the actual process, few moments carry the same anxiety and waiting to learn around the 5th day after egg retrieval, when an embryo will have reached the blastocyst stage or not, whether it makes a good candidate for transfer or not. And that determination, which ones make it, is not fixed genetic instruction, but this amazing cascade of intercellular signaling. There's this thing called the Hippo pathway activity. There's differential expression of transcription factors. There are mechanical forces from the zona pellucida. Each molecular signal reshapes the consequential cellular environment, and therefore then reshapes the next sequence of signals. And this outcome, which embryos become viable blastocysts, is not legible at any single cell or any single moment. And it's only visible when you account for the comprehensive landscape and the comprehensive environment in which it's taking place. Now, I use this image as my entry point as a lawyer because deep down I'm a huge biochemistry nerd. No, I mean because the central argument of my chapter is essentially the same instance applied, that law and embryos moving forward, especially after Dobbs, that in order for us to understand the stakes of the moment, we have to take a step back, zoom out, and look at the full landscape, the full system, and resist a temptation to evaluate any single legal move or technical innovation in isolation. That means that we don't take Dobbs as an isolated decision about abortion or even IVF or reproductive rights. Dobbs is a seismic event in the broader constitutional landscape. It has destabilized substantive due process architecture on which claims to sexual liberty, contraception, marriage equality, and the right to parent have all depended upon. Embryos do not just sit outside this landscape, but at the core of the intersection of these rights. Laws about embryos make claims about family, about genetic relatedness, about which reproductive choices the state endorses, and those claims radiate way beyond embryos and IVF and touch legal personhood, LGBTQ family formation, and racial equity in healthcare. So to evaluate any one proposed regulation without accounting for this full landscape is to miss what's really being built. I offer in my contribution to today, and hopefully to our book, a reproductive justice frame that a reproductive justice frame is uniquely suited to capture this full landscape. And through it, we can see how lawmaking regarding embryo disposition and IVF provision to minimize embryo destruction is happening alongside sustained anti-LGBTQ mobilization and a rollback of diversity, equity, and inclusion initiatives and the delegitimization of evidence-based medicine. The reproductive justice framework I offer insists that we hold all of that context in view simultaneously, that we ask not only what a proposed law says about embryos, but what it says about whose reproduction the state values, which family forms it ratifies, and who will bear the costs of enforcement. So my chapter has 4 parts: pre-Dobbs, Dobbs, IVF and reproductive justice, and reproductive justice as applied to laws regarding restorative reproductive medicine and embryo disposition cases. So pre-Dobbs, Roe v. Wade shaped the environment of law on embryos. Roe implied that aggressive state intrusion into reproductive decision-making would face serious constitutional headwinds. Scholars, many of them in this room, whose work I deeply respect, debated the extent of those protections as applied to assisted reproduction. But the implicit assumption underlying most legal and regulatory analysis of IVF was that some constitutional guardrails existed. Dobbs removes that assumption, and the history and traditions, air quotes, methodology that the court deployed in Dobbs offers IVF little shelter. First, as 2 of our very esteemed conveners point out in an article of the Journal of American Medical Association, IVF did not exist until more than a century after the 14th Amendment, the Due Process Clause, was ratified. So claims to a right to constitutional protections on IVF extrapolated from other substantive due process rights besides Roe or Casey are unlikely to carry the day with the current court. Moreover, Justice Thomas's concurrence made explicit what the majority left implicit, that Griswold, Lawrence, and Obergefell, the very cases that one could draw upon to argue for constitutional protections to IVF and assisted reproduction, are themselves vulnerable to Roe's plight. As many will talk about today, LePage is one illustration of what the post-Dobbs landscape has ushered in. I won't go into LePage because others have, but the reasoning in LePage would have probably faced stronger constitutional challenges under Roe, or at least Roe would have likely constrained the court's actions. However, LePage also illustrates the political infeasibility, as Jinping described in her presentation, of total bans on embryo destruction or IVF, which is equally important in our understanding of what lies ahead. The political infeasibility of halting embryo production and destruction outright means that those who objected to creating embryos that will be destroyed will have to employ indirect methods to achieve their goals. In addition, the necessity of avoiding arguments to ban embryo destruction and instead pursue arguments to minimize it may create opportunities to disguise other motives in the language of preserving life. And this is where, in my chapter, I draw on the trajectory of targeted restrictions on abortion provision that took place in the early 2000s as a cautionary tale. We've seen this space, this moment before, in the wake of the Casey decision, when the court upheld Roe's core, but invited, and that banning abortion completely was still illegal, but invited greater regulation. I point to this in my book chapter, and I hope to explore it further, and I know my good friend Dove has some thoughts about how I do that in this chapter, as well as another law review article I have forthcoming. Okay, so quickly, in 2.5 minutes, applying the reproductive justice frame is my analytical contribution to this, our discussion today. Reproductive justice, for those who aren't familiar, is a movement and framework, importantly, led by Black women that was established in the 1990s. Reproductive justice is a social justice framework aimed and movement that emphasizes intersecting social identities, for example, gender, race, and class, and community-developed solutions to structural inequalities. That's not my language, it's the language of Sister Song, a nationally recognized reproductive justice organization. RJ asks us to grapple with whether legal intervention is necessary and serves the interests of those on the margins. It resists the default assumption that law is the answer. Specifically, reproductive justice first accounts for the recurring patterns of weaponization of law as a method of reproductive control. The history of procreation and law in the United States, in fact, is defined by aspirations to maintain power structures and privilege whiteness and preserve patriarchy while disregarding reproductive autonomy. Compulsory sterilization programs advanced under the banner of public health proceeded, eugenics programs targeted the disabled, the poor, and those minoritized by race, and coerced sterilizations of Black, Latina, and Indigenous people persisted well into the 20th century. This history, the RJ framework, requires us to hold in view and thus resist a presumption that legal intervention ought to be the default. Second, a reproductive justice framework centers those on the margins, and in so doing surfaces the stakes that I'm talking about that more conventional analysis leave out of the frame. Third, reproductive justice takes the normative work of law seriously. When Arkansas became the first state to mandate insurance coverage for restorative reproductive medicine, a set of approaches which, with little established to no established clinical efficacy for most forms of infertility, it was not making a clinical judgment. Reproductive medicine's appeal is theological and ideological rather than clinical, and is championed precisely because it avoids embryo creation and destruction. The mandate that makes a claim about reproductive choices the mandate, therefore, makes a claim about what reproductive choices are worthy of public support, which family formation the state endorses, and whose fertility care the law legitimizes. Importantly, RRM is not a solution to any fertility issues faced by LGBTQ or single people. I'll leave talking about, I'll just say I'm running out of time, so for the conclusions that Susan Crocken will be talking about later in the afternoon, my analysis tracks with what she has to say. So listen up later today. To wrap up, applied to the post-Dobbs landscape, an RJ-informed analysis reveals that the legal moves with respect to embryos are not discrete or neutral policy choices. They reflect coordinated efforts enabled by Dobbs' demolition of the substantive due process architecture, and advanced by aligned social movements whose goals extend well beyond any single piece of legislation. The RJ framework does more than unmask this coordination. It reveals what the stakes are. The stakes, stakes that isolated legal analysis underestimate. Lawmaking about embryos is not merely a technical question about the legal status of biological material. It is a determination about who gets to form families, on whose terms, with whose genetic material, and under whose oversight. It is a site where hierarchies of reproductive worth are either challenged or consolidated, where the state either defers to the full range of human reproductive life or encodes a preferred version of it into law. Those stakes fall with particular weight on people already marginalized by race, class, gender, and sexual orientation. And I hope that I'll convince everyone that the reproductive justice framework insists that we name these issues before we start and before we act, rather than after.
Thank you, Katie. Let's have a big round of applause for this whole panel. Thank you. Going first in the day is not always the easiest task. We have two mics that will come to you if you have a question. If you have a question, please raise your hand. I'm going to start with Glenn. I saw his hand.
It's a question for Yaniv and Lisa. You're right here, so this is convenient if you want to jump in. I'm curious about your view of the correct damages measures if we take the Georgia Supreme Court at its kind of word and says that actually wrongful birth, if it's disrespectful for the life, yada, yada, yada. So what is the correct damage measure for the fraud, for example, and the like? And then I guess if I can just lob a second one onto it, imagine you're a court that takes seriously, you're a court that's decided that abortion should be banned in your state, and you take it seriously. How should your wrongful birth jurisprudence look different than if you're in a state in the other kind?
Lisa, I want to give you an opportunity to weigh in as well.
I insist.
Oh, thank you. So I'll try to remember both questions. The first question had to do with the remedies. And, we touch on the remedies briefly in the paper, but we do more work when it comes to the remedies in other pieces that we wrote. But that's just going around your question and trying to dodge what is really a difficult issue of how to quantify the damages and weigh this against the non-existence problem of the child. We have a simple solution to that, which is compensate for the extraordinary damages that the parents suffered. We don't want you to quantify the life of the child. We don't want you to quantify existence versus non-existence. We don't even want you to quantify how much having a disability is worth. We just want the sperm bank to pay for what the parents paid to have, in the case of the Normans, Alex hospitalized numerous times, being kept under supervision 24 hours so he doesn't murder his brother. In the other cases of the genetic disorders, to pay what it would cost to treat those disorders. And in another set of cases, to treat children who suffer from the same autism that the donor has, so that they could be helped very early in life. We know that early intervention is very important in autism, and we want to allow the parents the money that insurance, as we know, doesn't fully cover, not even close, to help these children. So that's the answer to the first question. Remind me quickly about the second question. My juvenile
States that
Alzheimer's
allow or don't
kicking
allow
in.
abortion, how the jurisprudence should be different.
Yeah. What we think is that, you don't even need to get to wrongful birth. I don't want to force the arm of any court in a jurisdiction that does not support abortion to make wrongful birth an allowable claim. I don't think it's realistic. I think that judges have their own set of pressures that they respond to. What we do want the courts to do is look at the causes of action, the actual causes of action cited by the plaintiffs, and analyze them the way that we learned in first-year tort class. Go through the motions, say yes, no. If you get stuck on causation, do the hard work. You get stuck on damages, well, we give you a little solution, but do the hard work. Courts have been doing the hard work. Don't dismiss it by saying, oh, this is all very disrespectful to the life of the child, and just throw it out the window.
Thanks. Sonia, I'm going to try to go around the room this way.
So I wanted to follow up on Glenn's question, and thank you. I really enjoyed that chapter. This isn't exactly the question that Glenn's asking, but you're arguing that this wrongful birth has extended so far to include all these things. But I feel like there's always been sort of a bit of a debate about what exactly wrongful birth is, because there are a lot of preconception understandings of wrongful birth, and you're really talking post-conception and tying it to abortion. And so, maybe we could call it wrongful conception instead, but there's lots of disagreement about what exactly falls under the term. But couldn't a court just say, we think that you're devaluing the life of the child, whatever we call it. So I think not calling it wrongful birth doesn't entirely avoid the problem, and I think the Georgia court's going to come out the same way, whether we call it wrongful conception, wrongful birth, we're devaluing a child. So can we avoid the concerns you have that I think are going to happen in many states?
So I think you're touching on a super important point, and we, in the revised version of the draft, we're touching on exactly that. The plaintiffs have made this exact argument that, you're pointing at, which is, this is not really wrongful birth because the problem is not post-conception. This is really more akin to wrongful conception, which, for those who don't know what wrongful conception is, that's basically another kind of negligence claim against a medical practitioner who botched a vasectomy or tubal ligation, and as a result, a child is born. And so the plaintiffs in Norman and in a lot of the other cases before Norman made the claim, this is more like wrongful conception. And the Supreme Court in Norman actually addresses this head front, and the court calls it a false dichotomy. And it says exactly what you just said. Exactly. It says, we don't care about this dichotomy. What we truly care about, what the guiding principle here is that we need to look at the value of the life of the child. That's the guiding principle. And the court starts its opinion, with, value of life is at the heart of our civilization. We don't think that that's necessarily wrong. I mean, we think the court kind of stuck itself in a doctrinal faux pas by doing that, because in 1984, the Supreme Court of Georgia said, wrongful conception is fine. We're going to pay you a lot of damages for a whole lot of things. And then in 1990, wrongful birth is prohibited. And then in 2020, the Supreme Court says, well, everything that implicates the life of the child is, so we have a doctrinal problem there. But what we want is okay, respect the life of the child, that's all possible. But we think that, the most respectful to the life of the child is to support the child with their struggles. This is clearly a wrong. There is clearly a wrong here by a reproductive products provider. We all know that. There's no doubt there. But it's a wrong that right now stands without a remedy, because we say that we are so respectful to the life of the child that we're sending this family home with nothing.
Yaniv, thank you. I'm going to ask for little moderator's trick. I'm going to get 3 questions, and then also ask that especially questions addressed to other members of the panel, because we're limited in time. We thought that would be a good way to do it. So Carter, and then if there's other questions in this area, let's get them all out on the table before we turn to responses.
Thank you very much. These wonderful, rich presentations. Really, it's more reactive to the proposals and by way of advice to going forward and drafting and redrafting. For Dove, I was going to say, you probably have already looked at this, but the book that, to my mind, is the most exhaustive in its analysis of the EAB and its work, the history, the transcripts, is actually Ben Hurlbut's book, Experiments in Democracy. And he did a really deep dive into the complexity around those debates and conversations, which were about federal funding, as you know, of research touching and concerning IVF. And so that's just a suggestion. It's one really wonderful source to look to further explore the question. And then the other comment I had is there's a lot of discussion about the effects of Dobbs on legislative enactments and so on. And from the perspective of someone who follows these things pretty closely and who has a pretty good sense of what the right to life movement's perspective is on this question, is I can just share with you that the folks in that movement, I think, have a very different perspective on the likelihood of success of limiting IVF. I think their perspective is that the current political moment, if you look at what happened in Alabama, Alabama has been a case that has not hesitated to restrict abortion, even pre-Dobbs, and the almost uniform reaction of the legislature in Alabama
tracks what the political moment seems to reflect, which is a deep, deep support. And this comes from the top. President Trump has been extremely enthusiastic about promoting IVF. And the only constituency that I can really see for limiting IVF is the United States Conference of Catholic Bishops. Like there's not really the right to life movement itself. You look at the major organizations that drive that and drive the legislative agenda at the federal level and at the state levels, there's almost nothing. In Texas Right to Life, for example, built in IVF exemptions to their abortion restrictive laws. And so I think from that, in the interest, and I'm sorry to keep going, but one of the ideas of this conference is to actually share perspectives from very different points of view. And I can understand deeply the anxiety and concerns of people who are passionate about abortion rights, people who are passionate about promoting IVF, especially for in a broad way across the population. And it's funny to listen to those, not funny, it's interesting to listen to those concerns and to compare them with the perspectives of people who are in the business of promoting the right to life in the legislative space, and it couldn't honestly be more divergent. Like there's no optimism on the side of the right to life movement about restricting IVF in any meaningful way. And I will say, and unless I'm mistaken, there's not been one single law passed since 2022 that declares the personhood of the embryonic human being. There are, and in fact, as Jinping pointed out, there are carve-outs in a lot of these, and these laws would be impossible to pass if there weren't carve-outs, as my understanding from talking to the people in the field on both sides of these questions. So, and even a different reading of reading LePage as a pretty narrow case about interpreting a wrongful death statute in the face of a 2018 statute and in the face of a prior judicial precedent in the Alabama Supreme Court that declared embryonic human beings in utero to be persons for the narrow purposes of the Wrongful Death Act, rather than saying that they can be. And then in reaction to that, consumer protections concerns, access to justice concerns on the part of patients who no longer have any remedies now in Alabama if an IVF clinic negligently or intentionally destroys their embryos. So just a general point about the value of this conversation, because it's going to represent different perspectives, but also it's a very different point of view and set of predictions about what the future looks like. And I can understand why they're different, because folks don't normally talk to each other in these two different tribes. And I think that's a great tribute to this event.
Thank you, Carter.
Can I engage with the
Katie, can
comment?
you wait? I just want to get two more
sorry,
questions
that's right.
or
As well.
comments, and then let's come here to Ben.
Thanks. So thanks for this great panel. I have what is basically a methodological question about comparative legal analysis. So it seems to me that one can dive more deeply into the sort of European American comparisons by asking what's the sort of background kind of normative, you could even call it sort of constitutional understanding of the relationship between citizen and society, basically. And so like in the German case around the adoption of PGD, the sort of background discussion about that was, it had interventions from Jürgen Habermas, articulating how the sort of fundamental relationship was one of an unscripted future in which the kind of fundamental foundation of a kind of egalitarian, liberal, constitutional democracy depends upon a particular understanding of the person and the relation of one person to the next. So that sort of more important than the capacity of the parent to attend to the future of the child in whatever way they saw fit was to preserve that kind of most fundamental lateral relation between peoples, which is a fundamentally different understanding than the parent turned consumer in the context of a sort of medical, a sort of consumer market for reproductive medical technologies, exercises a kind of a discretion. And it seems to me it goes to the wrongful birth question, which of course, if you look at that on its head, the rationale for access to forms of reproductive technology, which have been experimental intrinsically, and in a sense remain experimental intrinsically by virtue of being deployed in human beings, and hoping for the best or whatever, there's a sort of rightful birth dimension to that if one presumes that risks of of effects outweigh the good of existence, then technology itself is inhibited. So there's a individualism associated with that discretionary judgment that is fundamentally contradictory to the German orientation. So it's a sort of question about what gets treated as part of the background. And just to Dove, there is a sense in which a transmutation has happened in the kind of conceptual repertoire, I would argue, in this country from 1979, because the circumstances of that market and the kind of normalization of those relations has become itself a kind of normative vocabulary. So it's worth asking, when then and now, like, what publics are you comparing when you're looking at public deliberation? There was an open future of the sort that the Germans seek to preserve, which maybe we no longer have.
Thank you. So here's what I'm going to do with my extraordinary executive director powers. We have some time at lunch and at the end of the day. We're going to go 5 more minutes, and here's how I'm going to handle it. I'm going to take 2 more questions/comments from the room, and then give each panelist 30 seconds to a minute to say whatever is most on your mind that you feel needs a response. Yenke.
Thanks for this fascinating kickoff of the conference. I had a question for Laura and Timo. You mentioned how the fact that the US clinics decide to proceed with embryo, do not want to proceed with embryo transplantation if the result of PGD indicates that there are abnormalities, could constitute undermining the right to reproduce. And I wanted to reflect with you a little bit, or ask you about your view on what such a right might constitute, if there is such a thing. And also, especially in the context of ART, which is of course different from contexts where individuals are able to conceive of a child without help, and especially in light of differences between positive and negative autonomy, and maybe different conceptions of welfare.
Thanks. One last question, Emma.
Thank you. My question was for Jinping. I have also looked at Italy and Germany, and then also Poland, which limits the creation of human embryos to, I believe, 6 human embryos. And while Poland does not allow for the destruction of viable human embryos, it does allow for the destruction of non-viable human embryos per their legal structure. And so what I was curious about is, if you are limiting the number of human embryos created per cycle, the typical assessment of embryo success rates, which based on your charts as well, look at per cycle outcomes and live birth outcomes, seem like they would no longer be the best representation of the overall success, namely because you have to look at total egg retrieval to live birth outcomes or egg retrieval to pregnancy outcomes. And so in the research I've done, and this has been reflected in a few PubMed articles, Germany and Poland actually have success rates on par with the rest of Europe, and in Poland's case, higher than Europe when it comes to comparing egg retrieval to live birth rate. And so I was curious if you had looked at those metrics in your old research and what conclusions you had come to.
Thank you. All right, we're going to give each panelist a minute, and I apologize for how impossible a task this is, but we have time at lunch and otherwise to continue to engage. So starting with Dove.
Well, thanks all, and for the salutary recommendations from Carter and Ben. Very grateful. I'm going to just adopt those, read more closely your book's engagement with the EAB, and very grateful. I think that's going to deeply inform some of these differences in the last 50 years and how we might both recognize a debt to past efforts and most constructively seek to recover some of this deliberative model in a way that could try and forge some common ground across what remain very deep disagreements. My quick comment is going to regress in our conversation back to the challenges about damages for wrongful birth and this idea that Sonia and Glenn raised regarding the value of a child. The answers so far to that have sounded in the register of normative and doctrinal claims. I want to offer an empirical response. Having talked to a number of children who are at issue in these lawsuits, they say they do not feel devalued. I appreciate that this question of value is largely an objective one about the message that is sent, perhaps independent of the intention of the message or the subjective feeling of it. But these children uniformly say, I was raised by my parent whose love I feel and know by virtue of our everyday experiences every day since. This money that is sought on my behalf is to help me, to support me. That is a reflection of that love. I don't feel unloved, unworthy, insulted by this legal claim made on my behalf in the context of a family relationship that means so much more to me than any legal abstraction could, and especially one that's going to provide some measure of remedies to help me. And so I think that these questions might also be confronted from that perspective as well, whether the claim is one worth worrying about at all, whether it is true as an empirical matter that children feel or ought to feel devalued.
Jinping.
Yes, thank you all. I first want to respond to Carter because I want to make it more clear that of the 33 personhood bill we have seen, 27 of them do not have a carve-out. But I agree with you that without carve-out, it's harder to get passed. But we did see, certain bills, they don't explicitly have a carve-out, they got passed. But it's very unique, I agree with you. So the point I want to make here is, having a carve-out is also not a guarantee to access IVF. And to Emma, I really appreciate your feedback, and I have read a lot of your posts, so it's nice to see you here. Since our paper got changed a lot after our presentation at Law and Society Association, so Italy is actually a very new part of the paper, and so far we have only touched on Italy's literature, and my co-author, she has expertise in Italy, Germany, and Switzerland, so that's our next step. She will use her language skill and the legal analysis to add the other countries' analysis. In terms of Poland, we would love to hear your thoughts on that, probably look into that country as well. And we also consider adding Malta as an example, since I think probably you or the Chief Justice mentioned Malta as an example. So with that, 5,000 words, I don't know if I can squeeze all of them into the paper. Yeah.
Thank you. Katie.
Thanks. So I wanted to engage with Carter with your thought, and I mean, I couldn't agree with you more. I think that's one of the things, as far as the political infeasibility of complete bans. That's part of why I find the moment in time after Casey, when complete bans on abortion were still illegal, but greater regulation, the court invited, and we saw all this regulation. And one of the things that I think is really important for us to remember as well is that maintaining the status quo, from my normative priors coming into this discussion, I remember, it takes me to Judy Daar's book called The New Eugenics, right, which she talks about the lack of access it's not uniform, right? So if we look at states, for example, that have insurance mandates, almost all of them exclude LGBTQ people. If we look at access to Medicaid programs, like no one in the Cory Booker's and Duckworth's bill about IVF access talks about Medicaid. The bipartisan bill does not, right? So to my view, the status quo is not where we want it as well. So I don't want to limit our discussion about it to how bans can happen or not. I think that there is a lot that can happen, and it's indirect in that way, right? Like those are the things that I'm concerned about, is that are things like this, that the status quo, nobody's talking about Medicaid coverage for IVF, right? And we know because wealth is stratified by race in our country, that there's racial implications to that, right? And of course, definitions of infertility in statutes also mean that we can exclude LGBTQ people and single people. So I agree with you that bans unlikely, but I think that's why my eye is generally on, like, what are these things that feel like they're in the periphery or might not be obvious ways that we see desperate access continue. That's where, as Rachel Maddow would say, watch this space. That's the space that I'm watching.
So first of all, thank you for these terrific comments on the paper. I'll just say, Glenn and Laura and the editors, I think that in light of the many comments that we received, we should be allocated 10,000 words. I will cede most of my time back because I feel like I've talked too much already. But Dov, one little comment to your kind of perspective on the EAB. My impression has always been that the EAB hasn't really completely disappeared. It's kind of transmutated. So it took a hiatus during the Reagan administration, and then it came back as the National Bioethics Advisory Commission. I know. Transmutated means, it changed, it shape-shifted. And then, of course, it came back as Carter's President's Council on Bioethics, and then maybe it's taking another hiatus since the Obama administration. But I think that trying to start afresh with the EAB maybe doesn't take those developments under consideration. And you should be looking at those as well and what they did and how they work.
Thank you. Laura and Timo, you get the last word, the last minute and the last word.
Thank you for all the questions and comments. I will try to answer very shortly. Ninka's a fantastic question in regard to right to reproduction. Here I refer to Takeshi et al. Empirical study, whereby what they found out was that the transplantation of the blastocyst was rejected based on the detection of abnormal embryo. And in this situation, most of actually these couples involved in the study, these were almost 300, they were at very advanced age and already undertaken many cycles of the IVF, and they felt deprived of this right to reproduction and also deprived of right to choose and discriminated against those couples who did not do PGD, as for them the transfer was made and the possibility of abnormal embryo was also there.
Yes, and I will briefly add to this. I think everybody can hear me. These were excellent questions. There were certainly some of them longer than my answer. We have, of course, an enormous variety of different approaches in Europe, right? If you want to talk about this, and we have been doing research in stem cell patenting, stem cell regulation, I think since 2006 probably. And you can see an enormous variety. I think this commercialization of this issue is, of course, a matter that needs to be discussed also with regard to your comment on the Habermas ideas and doctrines on this. I think the core in Germany is that a human being should not become the object of our doing. It should remain a subject, and that is, of course, somehow you could say there's some tension with this commercialization aspects of the entire narrative that we see right now. But we also see an enormous variety of different approaches in Europe and different relationships between citizens and their states, different levels of trust as well to regulators and to clinicians and doctors. And we see also cases, for example, in stem cell research where moral problems or legal problems were exported to other countries, for example, with regard to stem cell banks in Israel, where Germany was relying on Israeli stem cell banks. We also see a long history of misunderstandings of the technology, even on the highest level in Europe. The Court of Justice of the European Union has made quite grave mistakes, for example, in the Brüssel judgments on these matters. So I think, and we at the Center of Advanced Studies in Bioscience Innovation Law in Copenhagen, we gather the Scandinavian, the Baltic, even South European, and Central European and UK perspectives. So we are interested also to involve in this kind of research. Thank you.
Wonderful. Thank you. Everybody, thank you very much for your attention. The panelists.